Uh, so, my friends, ladies and gentlemen, good evening, good morning, or good afternoon, depending on where you are located. So, welcome back to this DUT webinar series on US intellectual property and patent topics. Today, we are honored to have our guest speaker, Daniel. Now, please allow me to make a quick introduction of Daniel. But of course, I'm going to introduce in Chinese, since I guess most of our audience today would be Chinese. 今天呢，我们很荣幸啊，邀请到了这个我们的分享嘉宾呢是 Daniel 啊，Daniel 和博士。Daniel 呢具有法学博士学位，MBA 机械工程硕士与学士学位啊。Daniel 也是美国的律师、专利代理人、FINRA 和 NASD 的仲裁员啊，这两个机构分别是美国金融业监管局和美国证券交易商协会。在从事这个律所的这个律师业务之前呢，Daniel 呢曾经负责领导过塔塔集团艾森哲的相关部门的知识产权工作啊。在这之前呢 ，Daniel 还在福特公司啊做这个研发工程师啊，有多达6年。Daniel 呢，在这个知识产权，尤其是专利的诉讼领域呢，经验非常的丰富。这一次呢，我们也是非常荣幸能够请到 Daniel 来，给大家呢用这个基于的一些实际案例，给大家就美国专利诉讼来做一个专题的分享。关于 Daniel 的这个介绍呢，我今天就不占用太多时间。具体的这个更多的关于 Daniel 更多的这个丰富的这个从业背景呢，大家可以去Daniel 的这个律所的官方网页 Resolute 这个律师事务所的这个官网上去查看，好吧？那我今天呢就不再赘述。那接下来呢，我就把时间交给 Daniel。So Daniel, please take it away from me now.
OK， 谢谢。所以我用我这个 presentation， 我就刚用英文。所以所以我的中文名字是何立忠，所以谢谢。所以我现在开始我的 presentation。
I believe you can share now. I have stopped sharing.
Yes, I think so too. Can everyone see? Can you see my presentation now?
Yes, I believe so.
Okay, great. And so, thank you, Ben, for introducing me. So let me just start the presentation now. Apologize. Okay. So you kind of went through my introduction, so I'm not going to go much into it. So I went to law school at Case Western University. I have my MBA from the University of Illinois, and also I have my master's and bachelor's degree from Michigan. And so I have like 25 years of work experience, including 10 years over Accenture and Telecommunications, as been mentioned before. And also I have 15 years of law firm experience at general practice law firms and also IP boutique firms. And so what I'm going to do today is I'm going to go through some of the general legal principles, but I also think that'd be kind of interesting for me to go through some of my experience, either as a law firm attorney or when I was in-house. And so, so I'm going to include some case studies that's based on my legal experience here. So let me go through what I plan to talk today about. So first thing I'm going to go through as a general introduction into patent infringement. So that's going to go through, what is a patent infringement? What are the, different aspects? What are the different type of patent infringements? And then also I'm going to talk about nexus forum. I know that's kind of a topic I was told that some of the people might be interested in. So forum is basically where we can litigate. So here in the United States, we cannot litigate anywhere we want to. There are certain requirements to litigate in whether we litigate in state court or in federal court. And then once we're in federal court, basically there's, we've got 50 states here, and also within each state, a lot of times there's different courts within, district courts within a state. And so it depends on, what we talk about later on in the forum. We're going to be discussing in terms of where we can, bring a case, a patent infringement case. And then I'm going to be talking about, the different stages of a patent litigation. So we'll talk about, from the beginning, if somebody filed a complaint, which I'll talk about later on. And then the main part of the patent litigation I'll be talking about is what's called a markman, and that would be where the claim construction happens. And then so I'll be going through that, because that's really the main part in terms of a patent litigation that kind of breaks or makes the litigation, make your position when you're there. Then later on, like I mentioned before, is that I've got 25 years experience in either in a law firm or in-house experience. And so I'm going to go through in terms of some of the case studies, that arise in some of the patent litigations that I worked on. In particular, how the claim construction really affected those particular cases. And after that, I'm going to go through, section on damages in terms of what are the damages that's available for patent litigation, and then what damages kind of make sense in certain situations. And then the final section I'm going to go through is about ITC, which patent disputes, in terms of what can be brought up in an ITC patent dispute, and what kind of resolution that the ITC can provide. And then at the very end, I'll go through another case study of an ITC general exclusion order that I was involved in. So in that case, I was involved in as the litigator for the district court. And then after we had a decision from the district court, then the case was brought before ITC. So I'll bring up for that particular aspects of it. I'll discuss in terms of the very beginning part of it is when we actually started the litigation in the district court and how it ended at the ITC. So to give you an idea about how the ITC proceeding works. So let's go through the first part, which is patent infringement, and then some of this you might know already, maybe through what my partner Jessica presented earlier. And so patent infringement is excuse me, let me try to move my screen. It was blocking part of my presentation, the pop-up. And so the patent infringement is basically when somebody makes, use, offers to sell, or sells a patent invention. And so you might even see those particular terms, not even not just in patent infringement, but for those of you who may work in contracting aspects of it, especially like a license for intellectual property. Those are very typical terms that you see a lot, because in contracts, when you get a license, what you're trying to do is prevent someone from suing you once you have a license. And so those terms, make, use, offer to sell, or sells, is a very common things that you would see in terms of patent infringement and also patent licenses. And so I can kind of go through very briefly, but they're kind of self-explanatory. So make is basically somebody makes a product that is covered by the claims of the patent. And I understand, I think there was a section that you may have been involved, you may have participated earlier, which is on patent prosecution. And so claims, as you understand, is the last section of a patent, and it says I claim, which I'll go over in some of the examples I have. And so makes is that you make that product that is covered by the claim of the patent. So uses is that okay, I didn't make it, but I use it. And so this covers the kind of catches someone who's not only the manufacturer, but someone who used a patented product. And so so you can bring in actually a defendant who actually use it. So for example, like someone, obviously could be a product such as, like let's say a computer. Let's say this, ideally, if I have a Dell computer and the Dell computer infringes a particular patent, they can go after Dell, but they can also go after me as someone who uses it. More commonplace that might come up is software, which is, let's say, SAP, which I might use an example later on, even though I don't have it as a case. Let's say SAP write a software. Somebody else like BP might use that software, and then now BP, because they used a software that infringe a patent or some other aspects of something, they might be brought in as a party in addition to the manufacturer. And so the other ones are offer to sell or sells. And so this one will be like a distributor. Let's say, let's say that there's a product that was made by a manufacturer, and then now it's going to Home Depot. And I'm not sure if you know what Home Depot is, but Home Depot here is, a company that has this huge, I would say, store that sells all kind of home equipment and stuff like that. They sell anything from basically light switches to faucets to bathtub, toilets, anything that's home related, they would sell. And so let's say a manufacturer makes something, and then they sell it to Home Depot to sell to the eventual user. Home Depot can also be brought in as a defendant in that case, because they are offering to sell the product even though they don't make it or they don't use it. And so that's what the a lot of the infringement are based on. And obviously there's also import into the United States. And so in that case, it's not just to make, use, offer to sell or sells the product actually here, but someone who imports it. And so that's to try to catch someone who, it's, we're going to cover later on in terms of the ITC also, but imports could be someone who actually is in the process of importing these products. And so that could be another party that can be brought into a patent infringement lawsuit. And so what we talked about earlier were actually direct, what we call in the US called direct infringement. And so these are the people who actually directly infringed, by either, let me go back, in terms of makes, use, offer to sell or sells, or imports. And so these guys are what we would call direct infringers, because their action directly caused the infringement. There's also in the United States here what we call inducement. So this would be like whoever actively induced infringement of a patent. And so this would be someone who maybe they didn't actually cause the infringement, but then they might be working with someone else, right? So I might be working with another company, let's say. My company works with another company. I don't manufacture anything, I don't make anything, and and I don't sell anything. But then let's say I work with this company. Let's say I'm a consulting company. Okay, so I tell this consulting as a consulting company, I work with this company, and I say, hey, you know what? You can make a product that's like this, a particular design. And so we give them the particular design and say, hey, this is how you can make it and stuff like that. They make it, and it turns out to be one that infringe, a patent. Now they can, I can also be brought in as someone who induced the patent infringement. And so even though like I did not do, let's say, the particular requirements for direct infringement, I did not make, I did not use, I did not offer to sell or import. But then because I provided the design, that caused these particular infringement, I would be considered someone who actively induced the infringement. And so the law is basically here in the United States is whoever actively induced infringement of a patent shall be liable as an infringer. And so in this case, then I can also be brought in as a defendant in a case, if I was involved in terms of inducement, meaning that, like I provide the design, I suggested them to do this, and then that caused an infringement. Another type of infringement besides a direct infringer or an infringer that induced infringement is contributory patent infringement. And so this is a third type of infringement that can take place. Now, contributory patent infringement would be someone, would be someone who have a component, and then that component is something that is maybe by itself does not cause infringement. And then again, that kind of goes back to the claim. If you recall in the section that that was discussing about what a claim is, and then writing a claim in the patent prosecution section, there's a bunch of different claim elements. So there might be claim element A, B, C, D, E, F. Apologize, I keep popping up. And then to get for a patent to be infringed, every single element must be met by the infringing product. And so in some cases, let's say I contributed to I'm a manufacturer of a product that has A, B, C, but I don't have D and E. So I don't have the other two components here. And then somebody else manufactures something and they have, D and E. And so basically there is a final product that infringed, but then I did not make all the all the components of that product that caused the infringement. And so what contributory patent infringement is trying to catch is people who made them, a component that is, the material part of the invention, so that way, but then yet I don't have all of it. They're trying to catch basically people who, are making basically the material part of the invention, say A, B, C, that's really the key part of the invention. D and E, maybe, let's say it's a container, that surrounds whatever the infringing, the main part of it is. And then and then component E is, an opening or something like that, which is really not that big of a deal. But then A, B, and C is the main part of the invention. If I made those main part of the invention and then know that, that this would be used in something that would eventually be an infringing product. So, then what they're saying is that, hey, you contributory infringe that patent. And so that's a way to catch people who did not do all the components, but that the major part of the components, which is what's causing the fault component. Now, a defense to contributory infringement, which, a lot of times if you allege such an infringement, is that it has to be something that is not a staple article, and so, or commodity of commerce suitable for substantial non-infringement use. So what that means is that, okay, like I have something that's, that people say that is causing the infringement, but you know what? I'm doing stuff that's basically what's out there before. It's not, like, because now we're talking about not everything that's in the claim. We're only talking about a portion of the claim. And so it's basically, the defense is that, I did not sell anything that was not already out there. So basically, let's say I'm selling, let's say the claim has, let's say, an internal combustion engine, and then they're saying, and then that was, part of the claim. And so now somebody come back and say, hey, you sell an internal combustion engine for a car, and then the claim includes internal combustion engine. And so you are liable for contributory patent infringement. And so the defense I have is like, internal combustion engine is a staple article. There's a lot of people sell internal combustion engines, and my internal combustion engine is no different than anyone else's internal combustion engine. And so I should not be held liable for contributory patent infringement. It's kind of a, like, I know that what I said was there a lot to go through, and it's a little bit confusing, but then think of it in terms of saying that, okay, like, this is to capture someone who made something that was really the novel part of the patent. And then what the defense is that I did not really make a novel part of the patent, because whatever I've been, I made or sell or use or whatever it is under the direct infringement portion of it, that was really something that was already out there. And so it's not novel, and so I should not be held liable for contributory patent infringement. And so let's go through the next step is, what are different ways to initiate a patent dispute? So we kind of went through, the different type of patent infringement. And then now, there's two parties, obviously. There's one that's the one that the patent owner, and there's also the one that's either being alleged of infringement or alluded to that they might infringe. A lot of times nowadays, I'll go through one of the reasoning about when I say alleged infringement is that right now in the U.S. anyway, a lot of times people won't come out and directly say, you infringe. A lot of times what would happen is that they would write a letter saying that, we think that you might want to consider taking a license under our patent. And so that's a way of saying you infringe without saying you infringe. If you understand what I'm saying. And so I'll go through with the reason why we do that here in the United States. And so there's the one that's being alleged, that's the patent owner, and also the one that's alleged of infringement. And so if you are alleged of infringement, a lot of times you can initiate a patent dispute by filing something in the U.S. Patent and Trademark Office. And I think this is something that my partner, Jessica, went through before. So I won't go through that with you here. And so there's obviously two ways of doing this. You recall she might talked about, there's what we call the PTAB, which is the Patent Trial and Appeals Board. And there, the most common thing to do is file an inter partes review, which is in a way kind of, all very similar to a patent litigation that we would have in the federal court, but then it only addressed the issue of validity of the patent. And also it's kind of a condensed version of patent litigation. So that way, the idea was that it would be much cheaper to do that than a patent litigation if what you're really concerned about is the validity of the patent. There's some downside to filing an IPR. I think, I assume that Jessica kind of went over that besides cost. But then, so I won't go through that here. And then the other thing you can do is it's not really litigation, but it's really an argument on paper with the Patent Trademark Office. And again, so it's also a lot of times reviewed by the PTAB, but it's not run like a litigation. But it's more of a paper filing, and it's much less expensive, which is the ex parte re-examination, which I believe my partner Jessica kind of talked over. So the other two that I will be actually talking about today would be lawsuits that's filed in the federal courts. And then lawsuits of federal court can be filed by two different parties. First, the party that alleges infringement, which is the patent owner, can file a complaint in the federal court. And then they can allege saying that, hey, so and so, they infringed my patent. So that's what a lot of the cases are more in terms of, especially now, is a patent owner alleged infringement of of another party. And also you can file with the federal courts. Oh, it's called a declaratory judgment. And a lot of times the shorthand for that is DJ, filing a DJ against the patent owner. And this is particular popular before IPRs. There was a lot of DJs being filed around back then. And so what a DJ requires is that there must be some apprehension by the party that's filing the lawsuit, thinking that the patent owner that saying that the patent owner actually alleged infringement. And so what the argument has to be, or actually the complaint that's filed by that party, is that, hey, the patent owner alleged that I infringed their patent. Because they alleged that they alleged that I infringed their patent, I am now filing a declaratory judgment against the patent owner, that I do not infringe the patent, or the patent is invalid. So it's still a little bit broader than what you would get in an IPR. But then what it does is that it brings basically this litigation to in front of the court. And there's a couple of reasons why we do that, which one of them is forum, which we'll talk about later on. And the other reason is let's say, and actually this is something that I suggested before to one of my clients, and they were a Chinese company that make light switches, and so they were alleged. So what happened was that their product was alleged to infringe this patent by a U.S. company, and then the patent owner did not sue the Chinese company directly, but they were suing, like the companies we talked about earlier, right? Like the Home Depot, that sells the stuff, and then Menards. So they were selling suing all these companies that were selling it, but they're not directly them. And so the patent owned, and so basically the Chinese company talked to us and said, what do we do? How do we get involved here? Because every time they sue one of our customers, we've got indemnity clauses with them. And so we end up paying all this money, but then yet we're not a party to the litigation. So how do we get in as a party to the litigation? So that way we can come in and say, hey, there's no, like on our behalf, there's no infringement, your patent's invalid. So they want to get in there. And so this is where we kind of recommend saying, hey, one of the things you might want to think about is filing a declaratory judgment against the patent owner. That they've been, suing your customers. They haven't sued you, they haven't brought you to the party, but then you want to be able to argue your case in front of the federal court. And so this is where like somebody's declaratory judgment might be beneficial, or like I mentioned, which we'll talk about later on, is forum shopping. So this allows you an opportunity to forum shop. And so the other thing that we can do is to with the patent dispute is to basically bring your case in front of the International Trade Commission, the ITC, and which I will cover in more detail later on. So I don't want to go into much detail at this point. Okay, so like we talked about earlier, forum is kind of an important concept here in the United States, in that sense that you can't just file a lawsuit in any court. There has to be, that court has to have jurisdiction of whatever you're arguing, or also jurisdiction of where you're arguing, before they can try that case. And so basically there's two things that they're looking at. One is the subject matter jurisdiction, which and also personal jurisdiction. And I'll go through those in more detail next. And so subject matter jurisdiction is basically, does the federal court have jurisdiction over this matter? And so, like I mentioned earlier, there's two types of courts here in the United States. We have a federal court, and then also we have state courts. And so the federal court is basically appointed by the president. So the president appoints, all these federal courts, judges, And then state court is, typically it's an office that's run, that they run for office just like they do like any other office, right? To be a mayor or whatever it is, right? And so these attorneys who want to be judges, the state court, they run for office and become, a judge within a particular county or city or something like that. And so those would be the state courts. And so now the question, now if we were to, bring an intellectual property case, we first had to show that this federal, that we can bring it into a federal court. And so basically there's two ways of bringing something into a federal court. First is that the plaintiff's claim raised a federal question. And so basically, as we went through earlier, as you recall, we went through, what is a patent infringement? So that is being covered by a United States code. And so that way, refer back to saying, hey, we're talking about a patent infringement. And so this is, under this United States code, 35 USC. So that would be a federal question because it's a code that's brought up by, that is part of a federal code. I'm sorry, a question that was brought up by, as part of a federal code. And so now, because it's a patent infringement issue, it raises a federal question. Now, I mean, you have to think about it, like make sure that when we talk about intellectual property, or actually a lot of these cases, you have to make sure that it is a federal question, right? So patent, like I went through before, that's covered by 35 USC, and so that is a federal question. Trademark, yes, that's a federal question because that's a federal, that's a US code that covers that. Copyright, yes, that's a federal question. Now, the thing that is not a federal question that's intellectual property is something like misappropriating trade secret. So misappropriating trade secret is more of a tort type of claim. If you're not familiar with law, tort is like personal injury kind of an issue. So that would not be covered under federal question. And also a lot of times, when we litigate things, a lot of times it would be something like contracts. We're dealing with a patent issue. A lot of times contract may be brought in, and so contract is not a federal question. That's a state question. And so misappropriated trade secret, contract, and a couple other issues that might come up. When we're talking about company to company kind of litigation. It's not a federal question, and so those actually would not be under, by itself, you cannot bring up to a federal court. Now, what you can do is that because you filed a complaint and then you tie everything together, so let's say I file a complaint that deals with patent infringement, but there's also the issue of misappropriating trade secrets. So not only what I'm alleging is that, hey, the defendant not only infringed my patent, but then they misappropriated my trade secret because I disclosed, my trade secret to them, and they went ahead and used it without, a license. And so in that case, then both issues would be brought up in the federal court. And so hopefully that kind of makes sense. It says that all I need to do is to bring up one federal question and a complaint, and then I can kind of basically bring along some of the other issues that might not be a federal question along, to the federal court. Now, another thing that, is that the matter, even if it's not a federal question, the other way to bring in a subject matter before the district court, the federal district court rather, is that the matter in controversy exceeds $75,000. Obviously this is US dollars. And actually that's actually not that high of a standard. So most, I'm not saying most, but a lot of the, because I do litigation not only for patent infringement or trademark or misappropriated trade secret, but also I do litigation involving contracts. And so a lot of times the contract cases, we bring it up to the federal court rather than keep it in the state court. If it was a very small case, like $50,000 in dispute or something like that, obviously we don't have that much, much at stake, and then we just, bring it up in the state court. And also there's advantage of state court in terms of that, it's not as complex as a federal court. So the client doesn't have to spend as much money. But then if it's, let's say it's a case that's involving like $2 million. I mean, I just did one that's not too long ago that involved $2 million in terms of contract case. And that issue, like there's obviously not a federal question because it's basically, hey, these guys, said that we're going to pay you $2 million for your company. We gave you the company. Now I didn't get my $2 million, So now the controversy exceeds, $75,000, and we brought that in front of the federal court. Now, personal jurisdiction is the one that's a little more tricky, and the one that's probably more in dispute or disputed rather than like what subject matter jurisdiction in terms of whether we can bring something to the federal court. Now, and so personal jurisdiction would be, okay, we've now brought it into the federal court, not into the state court, but then now which one of these courts in the state can we make arguments, which we can bring the case in front of, basically. And so there's a, two prongs or two ways to bring this in, or two arguments rather, to say that why this court should have personal jurisdiction. First one is general personal jurisdiction. And so for that one, there has to be continuous, systematic general business contact with the form state. And so this would be like, let's say, the defendant is headquartered here. The defendant's headquartered in Delaware, which a lot of companies are, So like a lot of times Delaware is a good state to bring, that you can bring in a litigation, because that's where they're headquartered. And then there's the other aspects of it is specific personal jurisdiction. And so here they have to have some kind of activities within that jurisdiction that resulted in the injury to the plaintiff, and so basically resulted in infringement that created the case or controversy. So that what that basically says is that the common way of doing this is that the defendant, they're headquartered in Delaware, but then I'm based in Illinois here, right? So they sell their product here in Illinois at Home Depot. And so because they sell the product here in Illinois at Home Depot, I can bring, the court here in the Chicago area, which is the Northern District of Illinois, would have jurisdiction to hear this case, in addition to Delaware and wherever other state they actually sell the product to. Okay, and so that's what specific personal jurisdiction is that if you look at basically where the infringement took place. And then one thing that I know that kind of comes up quite a bit is that it has to be actual infringement that took place. Sometimes it's like just being there doesn't mean, or having a presence there doesn't mean there's infringement. It doesn't mean that the court has jurisdiction. You have to show infringement. And so something like a trade show, they could be argue that, okay, there's an offer to sell these trade shows, okay, but then they might say it wasn't offered to sell. We were just there, telling people about our product. We weren't trying to sell anything. And so in that case, then it's, arguably, maybe it was an infringement. And the more likely place that, or actually most likely activities that people argue about whether that would be a personal, a specific personal jurisdiction, is something like selling something on the internet, because, you put something up on the internet, right? It goes everywhere, and here in the United States, anyone in the 50 states can probably get access to it. But then you have to be able to show that somebody actually bought something from you, over there. And so something like the internet sometimes is not sufficient because there has to be an actual infringement that took place here. So next, like I kind of alluded to earlier, is form shopping. You might have heard that term before, And this is something that actually, the courts do not like, that attorneys do, but attorneys do it all the time. I mean, it's if you don't do form shopping, you're probably not doing your job, and so form shopping is really referring to, as a litigant, as the one that is filing the complaint, what form to file the complaint in. And so a lot of times I kind of mentioned about saying that, like, hey, there's this different type of personal jurisdiction. There's, you can either file it and where the company is located, or you can file it in a place, where they have sales activities, or, like an actual infringement in which somebody actually bought something that infringed, right? So this can cover a bunch of different states, a bunch of different, territories within that state, right? And so what form shopping is getting at is that you want the whoever files the complaint, they would look at what form, what district court is most beneficial for the case they're hearing, and so this happens basically when there's a bunch of different jurisdictions that a plaintiff can file. Then now they're trying to figure out, okay, which one is the one that's most beneficial for us to file it, and that's form shopping. Okay, and so kind of alluded to what are some of the reasons why somebody would want to form shop, right? And so, one reason is that the jury is more sympathetic to the local companies. So I'll go through, actually, I'm going to give an example of that later on. But basically, if I'm, headquartered here in Chicago, I'm suing a company that's based in Florida. Actually, that did happen to me. we were suing a company, Burger King, that's down in Florida, but then our client, Brown's Chicken, was actually based here in Chicago. But Burger King has, they're a fast food chain. I'm not sure familiar with them. They're like McDonald's, right? And so they have stores all over the United States. And so for us, we want to sue them here in the Northern District of Illinois because, people's going to know Brown's Chicken, and they might even have family that works with Brown's Chicken. They like eating at Brown's Chicken, whatever it is. They want the economy of Chicago to be better, by having Brown's Chicken do better. And so they're going to be sympathetic to the local companies. And so that's one reason you want to, form shop, what court would be most beneficial to you. Another thing, form shop, which obviously getting a bad name now, especially for this reason, is that some jury are some of the jury in certain areas are more friendly to smaller companies, and this is more evident in the Texas courts. And then if you notice, if you've been involved at all with patent litigation here in the United States, probably in the last 15, 20 years or so, there's an uptick in terms of cases filed in Texas courts. And the reason why that is that the jury are just much more friendly to smaller companies than larger companies in Texas courts. And also, I mean, don't want to be prejudiced or something like that, but then the jury in Texas courts, I find, is less sophisticated than some of the other areas. And so in a way, if it's something that's a large company, you're arguing more kind of a sophisticated kind of an argument. That's Texas is probably not the place you want to be. In fact, when I was at Accenture, we had a case that was in the Western District, I believe. I can't remember which district it is in Texas. And then the issue was misappropriating a trade secret. And so in that case, I kind of mentioned about how, who are infringers and who are not infringers. And so in this case, I was an in-house attorney at Accenture, and I was the IP expert over at Accenture for litigation. And so what happened was that Accenture worked with this company called WellLogic, and WellLogic, they're we were actually considering buying WellLogic at one point, and this is before, luckily I wasn't there at that time, or actually I can't be blamed for it, but apparently, there was WellLogic provided Accenture with their source code, for some for this one software that WellLogic owned, and so Accenture had the source code, but then we really didn't do much with the source code. I think a lot of times we get source code for like mergers and acquisition. That is more to see if there's open source issues with it. So we didn't really like evaluate the source code, but then we would probably, just like any other mergers and acquisition, you send it off to someplace, look for open source software, and then there are open source software, we'll try to fix it. That story for a different time. But then the other parties that were involved was that we start working with that what originally was supposed to be meant, that software, we start working with them for one reason of possibly acquiring them, but also to implement that software over at BP. BP is a petroleum company. That's petroleum company, that has they have refineries, everywhere, not everywhere, but they have obviously refineries in Texas. Also have a lot of gas stations that's over in Texas. And then what happened was that we decided, or Accenture decided not to use WellLogic, but then decided to work with SAP. I'm not sure if you're familiar with SAP, but they're they're a German company, a software company. So we started working with SAP, and SAP was the one that we used SAP software, and then implemented that software with BP. And so what happened was that WellLogic decided to sue us, sue actually all three of us, right? They sued us, Accenture for misappropriated trade secrets, and then we misappropriated trade secret to SAP. They obviously sued SAP, and they sued BP. SAP and BP was here to get out. SAP, they had a arbitration agreement with WellLogic, and so the arbitration agreement is basically saying that it has to be arbitrated over in Germany, and so they were to get out of this case over in Texas. And then BP, was able to settle the case, for fairly low value actually. But then Accenture, we kind of wanted to fight it, and so the argument that WellLogic had was basically saying that, hey, if you compare the source code that we provided to Accenture, and then that was in the SAP source code, there was a lot of if and then statements. And I'm not, I'm not sure how many people here are, I assume that a lot of you, that, write software before. And so, like if and then statement is like typical in all source codes and all coding, right? So because you have to make a decision about what what information you received and what to do with it, and so it's going to be filled with if and then statements. And so that was the argument by WellLogic, saying that, hey, if you look at the two source codes, there's a lot of if and then statements, so Accenture must have given our source code to SAP. And then so we were going like, oh, come on, give me a break. Like I said, it's, anyone that understands software would know that there's going to be, any programs would include tons of if and then statements. And so what does that, how does that show that there's misappropriated trade secret, right? So that's we went into the court with kind of a, cocky kind of a attitude, saying that there's no way these guys are going to win, right? And so that's why we didn't settle. But then which I learned a bunch of times, is that juries are unpredictable. So the jury did not like us saying that like this is this argument doesn't make any sense, because all software have if and then statement. Because I was told middle of the trial, so that they looked at the jury, and the jury basically felt like, they looked at us as if we're talking down to them. this big eccentric company, against this underdog little company, and then so they basically went on gut feeling, like who they like better, and then they basically apparently none of the jury, if they did, they didn't apply it, but ever wrote programs before. And so in this case, like the jury found this whisperer trade secret, which we were shocked, and then it was a huge amount of money. I can't recall exactly what it was, but I think it was over like $100 million in damages or something like that. I don't quote me on that because I don't recall. I remember it went up appeal a couple of times and things like that. But it was a large amount of money, in which on an argument that I thought was like a ridiculous argument. But then because the jury was probably less sophisticated and then less friendly to large companies, we got nailed with that. And so, a third reason why, somebody might go to, a certain forum is that, some of the courts are very experienced in patents. The California courts are very experienced in patents. Like the Northern District of Illinois, District of California, the Central District of California, that's where Silicon Valley is, right? And so those guys have patent. I mean, there's a lot of patent litigation that go through those courts. They have like specific patent rules that lays out, very clearly saying that, hey, this time, you file, after the complaint's filed, you have to do this, you have to have, whatever at certain times, right? And so it's very easy to understand and know, very predictable, in terms of the timing, and also fairly predictable in terms of how the judges would react to something, because they've been, patent litigation is very common over there, whereas some of the other places they're less common. So as someone who is a plaintiff, sometimes you want that predictability, and so you would follow the courts like that. So let's look at like where what venues, or where the courts, where most of these patent litigations take place. So we look at the first one, PTAB. Now PTAB, mentioned before, is basically litigation in front of a panel of judges that's at the patent office. So like these would be the IPOs and stuff like that, or IPRs rather. So those are the largest ones, and this is the one that Jessica, I believe, talked about earlier. And so if you look at some of the other ones, okay, so we've got Western District of Texas, you got the Eastern District of Texas, and then that's the reason why I was mentioning before, is that okay, those are popular forum to go to, because basically they're like anti-big companies, and then they're probably not as sophisticated as the people who live there, are not technically not. I think it's getting better because you've got maybe some of the some of the companies moving down there, but they're generally not as sophisticated as maybe some of the people in Northern District of California. And so if you look at like there's the two Californias, that's a good place to file. If you want someone that's sophisticated. Delaware, they're fairly sophisticated. We had some cases in front of Delaware, and the judges are pretty good, but also it's an easy one to go to, right? Because most companies are incorporated in Delaware. So that's always a company that you can go to no matter what. Northern District of Illinois, that's where I'm located. We adopted a lot of the patent rules that California has, and so we're getting more sophisticated in terms of how to, the judges are more sophisticated in terms of how to run a patent case. So that's another place to go to. And again, I mean, I'm not that familiar with New Jersey and New York, but then that kind of tapers down. So that kind of explains. So like where we see, you can tell a lot of this, except for the PTAB, obviously. But then this group here, you can tell that's a lot of it is due to form shopping. And so even if there is form shopping, that doesn't mean that if you're a defendant, you're done. You can always challenge personal jurisdiction. You can say, hey, like I actually did not sell anything here, or we were talking before. Let's say you're, they said that you offered to sell because you were at a you know, at a conference. You say, well, I didn't sell anything at the conference. All I did was make presentation, and so that should, so I did not do anything that would cause an infringement. And so there's obviously arguments, like you can make, if personal jurisdiction is not correct. The thing is that, if you don't think personal jurisdiction, is correct, you have to do that right away. If you let this run for a while, then the court's going to assume that you waived your challenge to personal jurisdiction. And so a lot of times, challenges to personal jurisdiction might come in right after a complaint is filed. Even before an answer is filed, before anything else is done, there would be a challenge to personal jurisdiction. That's where I see it. I haven't seen too many that was successful, but I've seen a lot of challenges. But then they just, I think it's the judges are personally say if there's anything that close to personal jurisdiction, we're going to allow it to stay here. Now I'm going to go through different stages of a patent litigation, and so here the first thing that happens is that the plaintiff filed a complaint. Okay, so the complaint can be you infringe the patent, or the complaint could even be hey, there's so and so, the patent owner say that I infringed their patent, and so I found this complaint to say that we do not infringe, and the patent is invalid. So the plaintiff, that's why I use the word plaintiff rather than patent owner, because the plaintiff could be also someone that's challenging the patent. Okay? And so the defendant at that time would file their answer, counterclaims, and defenses. Okay, so if it's a DJ, obviously the most common counterclaim is that you infringe, and then if it was the defendant is the alleged infringer, is like, I don't infringe, and your patent's invalid, and then afterwards, the parties would have initial disclosures as required by the court, and this is especially true in places like like Northern District of California or Central District of California, District of Illinois here. The court lays out saying that, hey, at this time, you must have an initial disclosure, and this initial disclosures are usually disclosures that you would typically see or ask for in a patent litigation, right? So this would be evidence of infringement. What patents do you think would cause this patent, or what prior art do you think would cause this patent to be invalid? It might be something like even like claim construction. We'll go later on. There's provide your early claim construction so we can know what it is. Okay. And so after that, there's usually some kind of negotiation protective order. Protective order would be basically because during discovery, which is the next stage, there's going to be a lot of documents flying back and forth, right? And so a lot of these things are confidential information. So it would be information that's confidential to the company, so especially like financial information. A lot of times one company might ask another company for financial information, let's say, especially the plaintiff, right? The plaintiff, the patent owner is going to ask the alleged infringer, say that, what's your sales, of this infringing product? They want to know that so they can calculate damages. But yet, some of this information is confidential. And so you need a protective order saying that, hey, like there's certain information that's going to come up during discovery. If it comes up, these things are not public. And then what you do with these information if you do that, a lot of times it's kind of like attorneys' eyes only. So only attorneys can look at it, but it can't be shared with anyone else. And the next stage would be discovery. I know that discovery is something that I'm not sure in China they hate it as much as the Europeans, but the Europeans really hate discovery because they have a very short discovery, whereas here in the US, we have a very long discovery. And so discovery is probably sometime a lot of people think of it as being abused in terms of how long it takes. And this is where actually most of the cost of a patent litigation goes into. And so there's different type of discovery that takes place, right? So there's document requests. And so I might say, provide me with all documents that shows, blah, blah, blah. Interrogatory is a set of questions that might ask the other side. So I said, lot of times this is trying to get the other side to admit to something, so that way you can kind of put it aside, saying that, do you, do you dispute that you sold products at Home Depot, and so that way I don't have to prove it. If they come back and say, yes, we sold product at Home Depot, I don't have to show that later on, or, there's a kind of admission at that point, deposition. And so deposition is basically, I get to depose, or actually not I, but maybe one party gets to depose the other parties. Either they're, their employees or people associated with it, what's going on and stuff like that, or somebody's, speaking on behalf of the company. So we can ask them questions, that maybe the documents that we receive is not clear. In fact, a lot of times the deposition is directed to documents, right? So I might depose someone saying, hey, you wrote such and such a letter, to this person. Here you said this, and what do you mean by that? So that's the kind of things that comes up in deposition. Now, expert witness, which I'm might go into later on, but then expert witnesses are, basically people who are experts in certain areas, and then we would have them testify as far as what they think. A lot of times, let's say for patent infringement, this might come up in, like I think later, I don't recall if I've talked about it yet. No, yeah. Okay, so I think I can talk about later on in the Markman hearing section. But then basically the claims, like if you recall, during the patent prosecution area, the claims are supposed to be written in a way that would be understandable to a person of ordinary skill in art. Whatever ordinary skill in art means, I think that's something that, a terminology that the court came up with, but then it's supposed to be someone who is, of the same skill as the inventor. So if the inventor has a PhD in chemistry, the person with skill in the art would be someone with a PhD in chemistry, right? And so we would a lot of times get an expert witness that's in that particular area. So let's say if it's a chemical patent, we would get someone who's an expert, who's a, probably likely a professor in chemistry in some, college, and come in and say, hey, like this term would mean this to me. I'm a person of ordinary skill in the art, and this is what it means. So that's what, one way that expert witness would come in was, basically for claim construction. The other place that expert witness would come in, which I'll cover later on, is for damages. So there's like damages expert witness, and so they would say, hey, I've reviewed, which I'll go over later on. I reviewed 10 license agreement in this particular field, and I think a 4% royalty is reasonable based on my review of all these agreements in this field, license agreements in this field. And so that's another place that we have expert witness. And so after the expert witness, actually the discovery, it lasted all the way, probably I would say like maybe 2 months before trial. And so here I listed as a bullet point, but then this actually goes all the way to, I would say, when we file pre-trial briefs. Okay, so it includes after Markman hearing and in between Markman hearing, and then when we file the pre-trial brief, it's probably might be like another half a year or so. So discovery, there's a discovery cutoff, and that's set by the judge. And then the next big point that comes up is a Markman hearing, which I'm going to spend quite a bit of time on later on. And also, after that, then the parties would file their pre-trial briefs, and then there's the trial. Now, what is a Markman hearing? That's if you work with U.S. patent litigation, you probably hear that term quite a bit. So Markman is actually the name of a case that was before the U.S. Supreme Court that found that the Supreme Court, and again, if you're not familiar with how we are here in the U.S., so there's a district court that we make the arguments in. If we don't like, one party does not like the outcome of the district court, they would go to what's called Court of Appeals. So there's different Court of Appeals here in Chicago. We have the 7th District is Chicago. But then for patents, all the patent cases goes to the federal court. So federal court is, almost kind of like, we always kind of joke around saying that's our Supreme Court, right? And so basically any patent issues will go to the federal court. Right, exactly. So it would be, the CAFC. And then the highest court would be the U.S. Supreme Court. And so let's say somebody does not like the outcome of the decision at the federal circuit, then it goes to the Supreme Court, And so, but then the Supreme Court, in order to go to Supreme Court, the Supreme Court have to agree to hear it. That's called certiorari. And so that, so you have to petition cert for the Supreme Court to hear it. Supreme Court basically had to say, you know what, I am not. Supreme Court saying, yeah, this is a decision. This is a kind of an issue that the Supreme Court has not held before. And so, yeah, this is something that's good to bring up to the Supreme Court. But the Supreme Court just will deny cert. We say denied cert. A lot of times they might be saying that this is an issue that's been addressed before. Don't bring it up to us again. So that's, and so in this case, it was it was before the Supreme Court, and then there was a case called Markman versus Westview Instruments, and then in that case, the Supreme Court held that the language of a patent is a matter of law for a judge to decide, not a matter of fact for a jury to decide. And so once that decision was made, there was what's called a Markman hearing now. And so what we have is a Markman hearing that's a pretrial hearing that probably takes place, like I said, about like maybe 6 months or so before the actual trial. And then at that hearing, the judge, both parties would go up and present, right? It's pretty much like a portion of a trial that, and then during that time, we would present arguments about saying, hey, these are the key elements, and this is what it means. So both parties would argue saying that this part, this claim element means this, and the other party might say the claim element means this. And then the Markman hearing is actually a very important hearing. And then okay, and I think I'll go through that later on. But then I think a different slide. But the Markman hearing is very important in terms of a lot of times the outcome of the case might depend on that Markman hearing, because the claim construction, after you get a claim construction, then a lot of times it's okay, everything falls in place, based on the claim construction, whether it be a infringement argument or invalidity argument. Okay, so here I listed 4 things to consider and claim construction in terms of the order of what to do in terms of claim construction and how to construe something. And again, I apologize if it was something that was gone over by either Jessica or maybe even during the patent prosecution section. But then claim construction, if you first thing you do is to look at the ordinary meaning, of whatever that term means. And then it would be to those ones that skilled, some that's skilled in art. That's all I was getting at. That's why sometimes we have expert witnesses, right? And so like, okay, so there's a certain term, and then this term a lot of times have a meaning to that particular field, and then in that field, what is a person that's already skilled in art would think that what that term means? And then the claim also should be read in view of the specification. Now, if you remember from the patent prosecution section, there's basically, I would say, 3 main parts of a patent. There's the drawings, which is part of the specification. There's the written specification, which is basically the written words that's describing what the drawing is trying to show. And then there's the claims, okay? And so the figures in the written part of it, they're saying that, the claim itself has to be read in view of the specification. And so what you do is that you go in the specification, and then you see, like what the specification says about this term, and then whether it's helpful in terms of what the ideas are, what the inventors think this term means. But I mean, in reality, it's what the patent attorney thinks, right? But then the idea is that, the inventor wrote, when they wrote the specification, they wrote the specification to mean a certain thing, and then that's the term that you should use. to interpret the claim. The other thing is that the prosecution history is also, is pretty significant in interpreting the claims. Now, the prosecution history is the history in terms of how the patent is being prosecuted through the U.S. Patent Office. And so like when we talk about like the patent prosecution section of this the presentation earlier, so patent prosecution would be like all the correspondence that's going back and forth between the attorney and the attorney actually is supposed to be either attorney or inventor, because the attorney represents the inventor, between the attorney and the patent office. And so that correspondence going back and forth. And that would obviously also include any prior art references that was cited during that time. That's part of prosecution history. And then if there's ambiguity that remains, an expert witness may aid in claim construction analysis. And the reason why that is, again, is because the expert witness is considered someone that's skilled in the art. Okay. So before I go any further, I'm not sure if somebody covered this before, but then there's a key concept called presumption of validity. And so the presumption of validity of an issued patent is that the patent is considered to be valid after the patent office issued that patent. And also part of that presumption of validity is that whatever prior art was cited in there, it's assumed that the patent examiner did his or her job and then reviewed all those prior art and determined that the patent claims are valid over those prior art. And so because of presumption of validity, as a practical matter, the alleged infringer, and again, this is probably something that was covered before, is you want to find prior art that's not cited during the prosecution. And so the prosecution, the applicant would disclose a certain amount of prior art or certain prior art, but also the patent office would have certain prior art. And so what you want to do is cite prior art that's not cited during prosecution, so that's that it's not cited by either the applicant or the patent office, and also not cumulative to the cited prior art. And I'm not going to go through why that's important. Is that if it's cumulative, then you always make the argument saying, hey, by cumulative, what I mean is that like the elements that you're cited to in the new prior art basically shows the same thing as the cited prior art. And so the argument is like the prior art that, let's say, the alleged infringer brings up, well, it's like, hey, these are useless prior art because it's already been shown by other prior art that the examiner looked at before. So like this new prior art doesn't do anything. And so here I kind of went through like why the Markman hearing is important, which I'll go through in terms of some of the examples that I'll be giving. Is that a lot of times the Markman hearing is directed to like some of the key claim elements that would either show that there's infringement, non-infringement, or it would show like the prior art covers this or not cover this. And so it depends on, you can usually tell by reading, the arguments by both sides as far as what's going on, what's going to be presented later on. Let's say the patent owner is, basically having a really broad, is reading this really broad, this claim element really broad. That usually means, that they're trying to cover the alleged infringer's they're trying to negate rather the alleged infringer's argument that it does not meet that claim element. So they're saying we don't infringe basically. But then now, the patent owner is reading it really narrow. What that means is likely that the alleged infringer has some pretty good prior art, and so you're trying to say, hey, the prior art does not cover this claim element, and so it cannot cause it to be invalid. And so it's a kind of a balancing act actually on both parties in terms of, you want it to be broad enough, if you're the plaintiff, you want to be broad enough, and so it covers the infringer's product, but yet not so broad that it's going to cover the prior art, or at least the newly cited prior art. So a lot of times once that's settled, it just like I mentioned, it just falls into place, right? Whether there's infringement or not. And that's kind of assuming that the judges actually do their job and interpret the claim elements rather. What I find is that a lot of times some of the judges, they know the game, they've been through this. And so they don't want to be the person that basically decide the case right there in the Markman hearing. And so a lot of times they just recite the claim element as its definition, and then when they do that, they didn't take either side's definition, and then it's just kind of like stops, as his job is, stops right there. And then he basically is kind of pushing it off to the jury to decide, even though, the Supreme Court says, no, this is a decision that should be made by the court, but then the court basically just restate the claim element, saying, such and such claim element means such and such a claim element, such and such a meaning, just reciting that. And so, it doesn't help any. And so a lot of times when that happens, then obviously it has to go to trial. And let me go through some of these quickly. I think I only have maybe half an hour left. And so I'll kind of go through a couple cases that I worked on, just to give you some ideas about some of the issues that deals with claim elements. Okay, so the first one is Ovonic versus Matsushita and Toyota.
Hi, Dan, excuse me.
Yes.
No, man, no hurry to just take your time. I mean, no hurry.
Oh, okay, thanks. Yeah, no, I realized I'm only halfway through.
Yeah, no problem. Yeah. We
Okay,
actually we can go to actually
the whole full 3 hours.
The schedule is from 8 to 11 actually.
Okay, great. Yeah, because I know that you wanted to initially try to save an hour for question and answer, but then
yeah.
I
So
think that this might be helpful for me to kind of go through some of the stuff. Maybe
okay. Thank you.
Some of the questions won't address some of the questions early, and so this is a case that I worked on. This is probably, let me see, about 15 years ago, I would say. And then the background of the case is that Ovonic is a company that's based in Detroit. It's in actually Troy, Michigan, if that matters. They're a kind of a think tank kind of a company. And their main thing was basically alternative energy kind of company. So they worked on obviously batteries, nickel metal hydride batteries here. They worked on like solar energy. I think they worked on wind energy also and stuff like that. So it's basic, and so that's actually energy conversion devices. This is the parent company. Ovonic Battery Company is the one that's within Ovonic that works on batteries itself. And so Ovonic actually started in the 60s, and then they were one of the first companies to really work on nickel metal hydride batteries, and so they had pretty much cornered the whole nickel metal hydride battery patent field back then. And so pretty much like every company, nickel metal hydride batteries, you've probably seen those. They were, initially they were in these little batteries, rechargeable batteries that you see. A lot of the like hand tools and stuff like that, they were using nickel metal hydride batteries. And so Ovonic actually, pretty much anyone that back then that used nickel metal hydride batteries had to get a license from Ovonic. And so Ovonic licensed actually nickel metal hydride batteries to a bunch of different companies. I think I know a lot of companies in China that use nickel hydride batteries had a license from Ovonic, and also Matsushita. Matsushita is the parent company of Panasonic. So obviously Panasonic is a battery company. So Matsushita has a license from Ovonic to use nickel metal hydride batteries. but the license that was Ovonic had pretty much with everyone back then was that it was for non-vehicular use. And so what that means is that you can use it for anything except for cars, or vehicles. Because, like I mentioned before, that Ovonic was based in Troy, and so they had a lot of associations with car companies, and so they want to reserve that part of it. They'll license it to be used for other stuff, but then we want to use it so that we can manufacture batteries for cars. So that was the idea of the original licenses that Ovonic had. But then what happened was that Matsushita started supplying batteries to Toyota Prius, using the nickel monohydrate battery technologies. And so I'm not sure Prius is popular in China or not, but Prius is actually right now it's a real pretty popular car. You see Prius around everywhere. And then this is about, like I mentioned, about like 15 years ago. And then this is when the second generation Prius just came out. And so first generation Prius wasn't that popular. Second generation, when it came out, like everyone, that's like about 2005, won car of the year. And then now it seems like Prius is taking over everything in terms of the hybrid systems, hybrid vehicle systems. And so that's when Ovonic was going like, hey, like we license it only for non-vehicular use, but now you guys put it in Prius. And so Ovonic sued Matsushita and Toyota in the Eastern District of Michigan, which is in Detroit. And then, like when we talk about form shopping, this is, obviously form shopping, right? And so Toyota is, a Japanese car company. It's obviously Detroit. Toyota is not well liked, over there. And plus, back then when I was working with them, Ovanic's CEO and president was Bob Stempel. You might not recognize that name, but Bob Stempel used to be the CEO of General Motors. And so he was a very well-known person over in Detroit, and actually a very well-liked person in Detroit, because he was an engineer, and then people really pushing for having CEOs for the car companies to be engineers. And so Bob Stempel was well-liked, and plus the car companies in Detroit. And so here's a perfect situation for us to be in the Eastern District of Michigan. But then I was mentioned there was a license agreement, right, between Ovonic and Matsushita. And so in there was the license agreement, there was an arbitration clause. And so because the arbitration clause, Matsushita was able to move the case to the International Chamber of Commerce. So it's the IIC arbitration. I'm trying to remember, I think they're based in Switzerland or something like that, somewhere in Europe. And so basically we had a case there, but then we litigated it here in New York. And so before the ICC, Ovonic, we alleged that the Prius infringed 3 patents. And so there were 2 patents that was directed to the electrodes. And so there was a positive and negative electrodes for the battery. And then also the one that I personally worked on was the battery pack system, which I'm going to call the 831 patent, or the 587 831 patent. And so what we did was that we asked the ICC to issue an injunction for the sales of Toyota Prius in the United States. And so here's claim 1 of the 831 patent. So it's obviously a fluid-cooled battery pack system and such. And so here's the element that was really being disputed. Okay, it says the width of said coolant flow channel optimally sized to allow for maximum heat transfer through convective, conductive, and radioactive heat transfer mechanisms directly from said battery to said coolant. And so here's figure 15 of the patent, and how that, so this illustrates basically, what these coolant channels are. Okay, so here the pluses are basically where the air comes in, comes in through these holes, and then it flows through these channels right here in between the battery pack systems. And it comes out, the fan draws it out, and it exits out of where these the negative signs are. And so basically it's saying that the width of the coolant channel is optimally sized to allow for maximum heat transfer. So it's basically this channel here, through, obviously different heat transfer means, directly from the batteries to the coolant. Now, during this time, what happened, if you can, those obviously the claim construction is going to be the main thing here. And so what happened was that the defendants, Matsushita and Toyota, they were able to find some prior art that showed, a channel, basically all these elements here, and then the only thing that's unclear here is like, okay, what does that mean? The width of the coolant flow channel optimally sized to allow for maximum heat transfer through, these different heat transfer means, is that they're arguing, saying that, hey, like the main thing the only thing that matters is that it allows for heat transfer between the battery and the coolant. And then we found, bunch of prior art that shows heat transfer from the battery to directly to the coolant, and so that would invalidate this patent. And so that's what they're trying to interpret. What this means is that basically they're saying that, hey, the channels allows for heat transfer between the battery and the coolant, directly from the battery to the coolant. So if we look at here, and so that's what the defendants are arguing. And then the reason, like the next page here is showing that the reason they're doing that is that because they were able to find channels, that was, coolant channels that was directly between the battery modules and the coolant. And so they're saying that, hey, because that was the only thing that was kind of dispute. They allege, they're saying, yes, we infringe. I mean, we meet all these other claim elements. It's arguably whether they infringe or not. They really didn't argue that much on infringement. They argued more on invalidity, based on this point. And so what we did, is that we looked at the prior art, right? So if you notice that here's the cited prior art. And so here there was the 204 patent that was cited. And so what we looked at here was that, like, hey, there was a battery pack system that was cited. There are channels, that was in between these batteries. Now the difference that we argued was that, you can see there are these plates with slots in between. And so we're saying that, hey, this claim, let me go back again, the width of said coolant clean channels optimally sized to allow for maximum heat transfer. What that means is that there's not a restriction going into the flow channel. So you can see there are restrictions by these slots that before it goes into the flow channel. So we're arguing that the width of said flow channel optimally sized to allow for maximum heat transfer means that there cannot be these slots. Obviously we didn't really say that in the specification, but then we're relying on basically the prior art, and then the prior art, or rather the cited prior art, and then the prior art that the Toyota and Matsushita brought up had slots like these. And so what we're saying is that, hey, like what you guys brought up here are just cumulative of cited prior arts. So we basically had a 3-week hearing on the merit of the case. And then what happened was that, we had actually 2 hearings, right? One on the merit of the case, and then one of them was basically a hearing on the injunction. And so the tribunal was basically asking questions saying that, hey, if we had an injunction, does this have to take place immediately, or can we wait for a couple of months? Is there any way to compensate in terms of damages and stuff like that? So basically our position is like, no, this injunction has to take place as soon as you make the decision. and then there's damages, monetary damages is not sufficient, for this case. And so that kind of probably scared Toyota enough, because I mentioned about saying that, they just won car of the year, and this is one, they're basically a car that they're really trying to introduce hybrid into this country. And so basically we both agree, they agree to settle the case. The case, the settlement agreement is probably like 2-3 inches thick. It's like one of the thickest settlement agreement that I've ever seen. And so, but obviously settlement agreements are confidential, so I can't disclose it. But then there was quite a few articles that came out saying that Ms. Schuster and Toyota agreed to pay combined $30 million. So that covered enough for our legal fees. But then obviously the agreement is much more than just monetary. And so the takeaway from this case that I want to say, about is that the prosecution history is this is one of the things I talk about, saying, what to look for in terms of claim construction. And so the prosecution history is, significant in determining the meaning of the claims. And so here, I just want to point out that prosecution history is not just, the arguments going back and forth, but it's also include the prior references. And so from a litigant standpoint, it might not be the same standpoint from a patent prosecution person, but the more prior art that you find and disclose to the patent office, the better. Because then it kind of like takes away from the prior art that can be because of presumption of validity, they can't make those arguments saying that, hey, these, that's the prior art is, causing the, would invalidate the patent. Or also, like if we have more prior art, then we have additional prior art to kind of say that, hey, the new prior art you guys are citing to is just simply cumulative, to the what's in the patent office. And so from litigation standpoint, this is something that has to be done during prosecution, is that the more prior art, the closer the prior art you cite to, the better it is for us. Okay, so let me talk about another case real quick. I'm sorry, let me get a drink of water here. It's Cryovac versus Pechenay. And so Cryovac is a company that make film. I'm not talking, I know a lot of people get confused when I say film. I'm not talking about like a film, like movie films. I'm talking about films that's a plastic or polymeric, film, polymeric material that's flat, and you can do whatever you need to with it, right? And so the example of this is the parent company of Sealed Air. I'm not sure if you heard Sealed Air, but Sealed Air is like bubble wrap, basically. They're the one that came up with bubble wrap, right? So that's what's called Sealed Air, is that they have film, 2 layers of film, and they capture air in between the 2 layers of film. So that's why it's Sealed Air. Okay, and so they have a bunch. So they're a company that makes multi-layered films, and then in particular, the film that we're talking about dispute here is films that's for meat packaging. Here in the United States, we buy food in grocery stores. A lot of times, they're pre-packaged actually. So let's say I go buy a piece of rib or something like that. A rack of rib, I guess is the term for it. They're basically, there's a film that packages it and it's all sealed. And so when I buy it, I know like it's I have to cut the seal in order to basically get the meat out of the film. And so both Cryovac have is that area, and also the company that I worked for, actually I was outside counsel at that time, is Pechenay. So Pechenay originally started off as American National Can. They became Pechenay, then they became Elcan. So that they changed a bunch of different names. By the time the litigation took place, they were Pechenay. And so the reason why these multi-layer films exist is that oxygen, would prematurely spoil the meat. And so, like if you look at a piece, meat that's like at a butcher shop that's not sealed, or, like with film, you can see it start turning a little bit brown after a little while, stuff like that. It doesn't look, I'm not sure if it's spoiled, but it doesn't look appetizing anyway. So the oxygen is what causes, the spoil, but also causes the deterioration or, of the coloring of the meat. And so there's, so there's multi-layer films out there that has at least one oxygen barrier layer. So the oxygen barrier layer prevents the oxygen or reduces at least the amount of oxygens that go through the layer to spoil the meat. And so Cryovac had a patent, 491 patent. That's directed to a multi-layer film, and then they sued Pechenay for infringing this patent, and also they brought in an extra issue of tortious interference with this client relationship. And as you recall earlier, I was mentioning that sometimes they would bring in a patent case, but also contracts, or in this case, it's actually not contracts, it's actually a tort case. So tortious interference is basically saying that tortious interference of a contract, that means that Cryovac has a contract with its client, and then because Pechenay's action, that contract was not, they did not uphold that contract, or they did not perform that contract, rather. So they're basically, they're alleging basically Pechenay stole their client. Basically what they're saying. So this is a case. So the tortious interference is not a patent matter, but then because it was attached to a patent matter of infringement, they were to bring both matters in front of the judge. And so let me go through like what the claim actually says. Okay, so the claim that actually we're just even in the preamble here, that before we have to get any further, says that by actually oriented co-extruded film, and then having 7 layers. One of the layers is ethanol vinyl alcohol, and then polyamide and things like that. Okay, so I think we all kind of agree. Agree that we meet these elements. What's out there, because this is something that they can just look at, test the materials, measure it, and say yes, it's there. Okay, and so the only thing that was being disputed is oriented co-extruded film, and even then you were kind of admitting, saying that like oriented co-extruded film seems to be pretty broad, and so what we did was that our expert witness actually found a prior art that had this exact same structure, and then the article described the structure, also described it as a biaxial oriented, and it was co-extruded film. And so we're going like, haha, we basically found this this prior art that's going to validate this patent. And so what the plaintiff did was that they went to their definition, and then they looked at the definition and said, hey, the term oriented and the like is used herein to define a polymer material which has been heated and stretched to realign the molecular configuration. This stretching process accomplished by a racking or blown bubble process. Now, for us, the articles that we found, was talking about the structure, because it was testing the structure, saying that how the structure of this film is great for an oxygen barrier, characteristics. But then because it's talking about the structure, the person that wrote the article, he was talking about a film that he, a couple films that he had for testing. He's obviously not talking about, he obviously does not have information or even discussed, how this film was made. So basically what, the patent owner was saying that, okay, you found an article that disclosed all this stuff, and you found, and then the article even said it's biaxially oriented and it was co-extruded, but then here they're saying that this stretching process must be done by a racking or blown bubble process, which we don't have information for, right? We suspect that it's, those are very common processes, but then we don't have information on that process. And so we weren't able to pinpoint that in terms of saying that, hey, like if this is how way it's construed, that this is then there's then we can invalidate it. And so this argument was brought up before the Supreme Court, right? And then so during the Markman hearing, the whole thing was basically whether this stretching accomplished by a racking or blown bubble process, this process should be part of the definition of oriented. They said it has to be there, obviously, so that way, our prior art does not disclose how the film was made, and we argue saying that no, it should not be included in there. This is basically you're improperly importing language from the specification into the claim. That was our argument. And unfortunately, I guess the judge adopted Cryovac's construction, and so it still makes it kind of ambiguous, saying that like if you look at the construction, all they did was that they took a section of the specification, put it in there, but it doesn't really say that it has to be done by this way, right? And so it still kind of remained ambiguous, and so this went to so we took this to trial, and so we obviously argued saying that, hey, like this prior art validates it and all that stuff like that. And then the jury, we believe, was more on our side because the jury awarded Cryovac only $1 million for a patent infringement and tortious interference claim. And so this is like, they asked for something like $100 million, only got $1 million. And they probably spent like $20 million litigating this case. And so wasn't even close to covering what that is. And so we think that the jury kind of agreed with us, but then basically gave him a token $1 million from infringement. And so the takeaway is that, like from this case that we talked about is that, the claims must be written, must be read and view the specification, but it's impermissible to read the specification into a patent claim. Now, in this case, it's difficult to ascertain, whether the purpose of the passage that that was cited was that to define the claim element, or is it an example of a claim element? If it was to define the claim element, yes. I mean, I guess the thing that was helpful for Cryovac is that like if you look back, the section that they took it from is definitions. So they said, yeah, that's defining the element, right? But then we're saying that no, it's not really defining the element, but then it's an example, the method of stretching. A third case I'll go through is that this is actually a case that I did not litigate, but actually I wrote the patent that was later on that was litigated. And so I thought that might be kind of interesting for you to see the viewpoint of a litigated case from someone who wrote the patent. Okay? So the case is actually with Articat and Bombardier. I'm not sure you're familiar with these two companies, but then Articat is a company that's based here in Minnesota. Actually, not here, but then it's close to here. It's in Minnesota. But what they do, like the name kind of allude to, is that they make snowmobiles. I mean, that's their bread and butter, the snowmobiles. And so I'm not sure if you guys have them in China or not, but snowmobiles has a track, almost kind of a track, kind of like similar to like a tank, like a tank has a track, a track like that. So it digs into the snow. There's a single track, somebody rides on it, and then when they pull on the throttle, the track turns and something like that. So that's what that bread and butter is. But in addition to making snowmobiles, they also make ATVs, all-terrain vehicles, which is basically like these small four-wheel vehicles that essentially looks like a motorcycle with four wheels, and also personal watercrafts. And then here's a picture of what a personal watercraft is. And so it's somebody else, usually it's a lake or because it's not big enough to be in something like an ocean or something like that, but a small lake. People ride these things here in the United States, and then they go pretty fast. They probably go like, it depends on the power. I mean, they go up to like 50, 60 miles per hour, So which is like 100 kilometers per hour. Um, and so they're fairly fast vehicles, and people just like to ride them. There can be a single rider that sits on it, or a rider sits in the back, and they zoom around in it. Sometimes they pull skis, behind it, and basically it's a easy to move boat that they can easily put on a trailer and bring it at times to the lake. So that's what the case is about. And Bombardier, I'm not sure if you guys remember Bombardier, but Bombardier, they also make recreational vehicles. The one that we're talking about here is Skidoo, which is what they make. But Bombardier, they also is they make airplanes basically. Lear jets. They're part of Bombardier. So they're a large company, and then they but then they also, in addition to like making Lear jets, they also make recreational vehicles. So the background of the case, or actually the patent suit rather, was that I was working with the general counsel of AutoCAD, and we were working on this material litigation, which is Polaris versus AutoCAD. So Polaris sued AutoCAD for its snowmobile for suspension. And so when I was there, I was working with them, strategizing about the case. And then he asked me, saying, "Hey Dan, like, don't you write patent applications also?" I said, "Yeah, I do." And he said, "No, hey, we've got this issue with personal watercraft, and so we need a patent application to be written. Is that something that you can do?" I said, "Yeah, sure, I'll be glad to." So the issue was that the personal watercraft, if you're familiar with personal watercraft, or basically thrust, type of boats, is that it doesn't have a propeller. There's no propeller in the back, and the reason why that is that like people would ride these things onto a beach, and then they, that's a lot of times they do. And so if you have a propeller, you're going to damage the beach, damage the propeller, right? And also it's written in very shallow water, so you don't want a propeller there. And so the way it works is that there's a thrust, there's an impeller here that pushes the water out, and then it comes out the nozzle at the end of at the end of the water being pushed out by the impeller, and so this nozzle is able to rotate, and then by the rotation of the nozzle, so when somebody turns the steering for the personal watercraft, it turns the nozzle, and this causes, when there's thrust, this causes the boat to turn or yaw, basically. That's what I was trying to indicate here with W3 and W6, is the yaw that takes place, when somebody turns the wheel, the steering, which turns the nozzle, and which causes the vehicle to yaw. So this is, so this is how personal watercraft works. But the problem is that a lot of people, what happened is that an emergency situation, let's say, the person is riding up into a buoy or something like that. I think that's a lot of times that's what happens, is that there's a buoy right in front of them, or a boat right in front of them, and the person panics. And so what they do is that, like, they release the throttle and then try to turn. Now, with this type of system, nothing happens. Because it's basically the turn is caused by the thrust coming out of the nozzle. If you don't have any thrust, you can't turn. And so what happened is that there's all kind of accidents that takes place. So like obviously when there's an accident that takes place, there's products, there's a product liability litigation. And so AutoCAD was being sued a lot, according to the general counsel. They're saying like any time there's like 3 to 4 litigations that's taking place because somebody crashed in the personal watercraft. And so AutoCAD came up with a solution for that, which is basically to have this. So this is the steering column. So there's a steering column or steering post, and then they put 2 magnets on a steering post and a proximity switch. And so the idea is that, when the steering is turned a certain amount, then it gets close to the proximity switch, and the proximity switch picks up that's being turned. And so that way, and so what happens is that the boat would recognize, saying that, okay, somebody let go of the throttle, and then the wheel has been turned, so that way the proximity switch recognizes that that one of the magnets is close to it and knows that it turned, then it'll give little burst of throttle so that way it can turn. So that was really what the solution to this is. All right. And so what I did was that during that time I prepared and filed a couple patent applications. I probably found like they're actually all either those initial applications, and some of them were continuations or continuation parts and things like that. So I had a whole family of patent applications that's directed to this thrust steering system for personal watercraft. And so that resulted in the issuance of 2 patents. And so AutoCAD, when I was there, AutoCAD, either through AutoCAD or myself, because my name was associated with these patents, a lot of them would come to us saying that, hey, asking for licenses, right? So we licensed it to Honda for use with its personal watercraft, but also pretty much, there's only a few companies out there that makes these personal watercraft, but all of them, came to us, know about our patent that was asking for a license, so but Bombardier, start using the system, using a system like this for Skidoo, but then they never got a license from AutoCAD, and so AutoCAD sued Bombardier for infringement of these 2 patents. So let's look at go back to the claims of what this patents has, and so like this is the what I wrote back then was a thrust system for personal watercraft, steering mechanism, that basically if you turn it one way, then it causes or actually so rotate clockwise and counterclockwise, and then a throttle system. And then here's the key part that was being argued, and actually was the key part for us to write this claim too. It says, control thrust steering system causes said throttle mechanism to increase thrust upon rotating said steering mechanism. And so what that's saying is that once I rotate the steering mechanism, the the control thrust system, which is the whole system we're talking about here, which includes basically the proximity switch and all that, the whole logic behind it, that would cause it to increase the thrust. And so that way, somebody lets go of the throttle, but then I turn the steering system, and that still causes some thrust to come out at the nozzle. And so that's really what it says. But then what Bombardier argued was that the thrust system, this is that this what I'm citing here requires the thrust system to increase instantaneously. So what they're saying is that as soon as I turn it, it's got to come out within like right now. There's like no delay at all, So basically, because what they're saying is that, hey, we timed our system, and there was a delay of something like, I don't recall what it was, so something like 0.3 seconds. So it's like less than a second, but there's still a measurable delay. And so because there's a measurable delay, then we don't infringe. That's what they're arguing. And so this went to trial. And again, I was not part of this because I wrote the patent, so I'm not a litigant. Usually the person that write the patent don't litigate their own patent. And so a trial, the jury found that both patents were not invalid. And so basically they found it was valid. And also they found by clear and convincing evidence that Bombardier willfully infringed the asserted claims, which I will go through that in the next section of damages, what that means, willful infringement. And so based on the willful infringement, the court trebled the damages, which said 3 times the damages that was being asked, resulting in a $4.67 million damages, And so basically, and also not on here is that there's a continued damages that would occur, if they keep using this. And so the takeaway from this is that let's just going back to the first element, of what a claim construction is. The claims construction begins with determining the ordinary and customary meaning of any which would be attributed to the terms by those skill in the art at the time of the invention. So I wasn't there, like at the arguments, like I said, I was the attorney that wrote the application, but I would think that the argument is that, they're just not being reasonable. I mean, this is not someone that is a person of ordinary skill in the art would not expect by turning the steering wheel that there has to be instantaneous change. Because I mean, it goes through different systems, right? There's electronic systems, there's you have to turn the steering wheel. Steering wheel takes some time to turn, So a person of ordinary skill in the art that's familiar with that kind of system would know that it cannot be instantaneous. And so basically the construction must be reasonable to someone that's skilled in the art. It can't be just make up anything you want, if that's not even, in this case, in my mind, it's not even feasible. And so let's next turn to damages. And so I believe this is some of the stuff that was asked before. And so let's go through the different type of damages. Let me go back here. Sorry. And so the different type of damages I'll be talking about is reasonable royalty, which is a monetary damage, lost profit with monetary damages, and then in addition to that, you can also ask for additional damages. There's treble damages. Remember, I just talked about that with the Articat case, in which the court found that there was willful infringement, and so the treble the damages, and there's costs, and so you can ask for costs in terms of attorney's fees and court costs. Okay, and then finally there's injunction. And so injunction, as you recall, that's what we asked for in the case, the Ovana case versus Matsushita and Toyota, in which we asked for injunction of the Toyota Prius. And so let's look at first one, reasonable royalty damages. And actually, this is probably the most common, I would say. Most of the cases I worked on use reasonable royalty damages. And so reasonable royalty damages, a lot of times how this works is that we would hire an expert witness to do the reasonable royalty damages. And so reasonable royalty damage is basically based on a fictional license agreement between the plaintiff and the defendant. And so what the expert witness would look at would be like, any relevant licenses that's in this field, and then, would that be affected in terms of exclusivity of the product to the patent holder? That might increase it somewhat if there's something that's exclusive to the patent holder. The value of the product, obviously you get a number, then the license might be, let's say, 5%. The product is worth $20, so it'll be $20 times 5% times the number of infringement, basically. And also, like basically, they look at any negotiation that could have taken place, that might increase it or not, and also, if there's any negotiation that took place, then they might look at, what was discussed back then. That happens sometimes. Like I mentioned, sometimes these things are start off as, saying, instead of directly saying that you infringe, you say that we think you should take a royalty from us at a 5%, something like that. Now, the other monetary way to look at is lost profit or monetary damages. And then this is the actual profits that the plaintiff lost. And so this would be like lost sales, lost profit, and not only current, but then this would be future lost profit or price erosion, because these guys are in this area, they basically lowered the prices down. Before, like probably maybe from Jessica's talk, is that patent is really a monopoly. It's a legalized monopoly. To have a 20-year monopoly on that particular product or whatever it is, that for 20 years, and so they just eroded my monopoly. Okay, so let's look at in terms of like why would sometimes somebody would pick, because I mentioned about there's two types of monetary damages, right? There's a reasonable royalty and there's lost profit. And so when would somebody use reasonable royalty and when somebody would use lost profit? And so you would normally use like lost profit. If you have the evidence for it, you know. And again, what I mean by that is like lost profit is something that's more difficult to prove, right? Because you actually have to have you have to show that, okay, like that you actually lost that profit because of infringing activity. And so you have to show this causation, which is sometimes not easy to show, because you can say, okay, there's, we lost some profit, but there could be some other reasons you lost profit. It could be the economy was bad. It could be whatever, like there's all kind of other reasons why, your value went down. But then you had to show that, okay, like the profit that you lost was due to these guys' infringing activities, not due to the economy, not due to, another party that might be having, that causes has an infringing product. There could be a bunch of other reasons, right? If you're the alleged infringer, they can come up with about saying why it's there's no the money that was shown as the lost profit is not really due to our infringement. And so really it depends on the evidence. And so that's why I was saying that most of the cases I worked on, probably reasonable realty is more likely the way people do it, just because lost profit is so hard to prove. Now let's talk about trouble damages. Okay, and so trouble damages is basically 35 USC, we mentioned before, that's a code, the US code for patents, and it provides that the district court judges has discretion to enhance damages up to 3 times the actual damages. And so this is usually done when there's willful infringement. So willful infringement is basically meaning that, okay, I was notified, I know about this infringement. Let's say in this case, Bombardier, okay? Bombardier was, it's a small industry, they knew that that Articat had these patents on their controlled thrust steering system. Other companies have gotten licenses for it, so it's well known. And then Articat presented this in trade shows. And my understanding is that, there were, when Articat presented this idea at trade shows, even, Bombardier had employees, that visited Articat's booth to more understand this controlled thrust steering system. And so they knew about this, but yet they still continue to infringe. And so that's willful infringement. And so I'm not sure if anyone talked about that before, but then the way to get around willful infringement, and this is something that any company really that's aware of problematic patents should do, is that a well-reasoned opinion of counsel, saying that the patent is invalid or not infringed, that is the best way to minimize the risk of willful infringement. And so what that means is that, okay, like I know about this infringement, but I keep infringing because, either the patent is invalid or I do not infringe it. And so that way I have a reason for why I keep infringing. It's not because I just don't care, it's like, I have an opinion of counsel. And again, the opinion of counsel has, normally has to be a patent attorney. And so it's maybe someone who's sophisticated in patents that can read a patent and say, yes, based on my, basically he's almost acting as an expert witness at that point, right? Based on my experience as a patent attorney, I don't think this patent is valid. But based on my experience as a patent attorney, I don't think this patent is infringed, based on the following reasons. And so the opinion can't be like a one-page opinion. Usually infringement is a fairly lengthy opinion that we'll talk about, which we didn't cover, is talk about like direct infringement, and talk about infringement under doctrine of equivalence. Obviously I didn't have time to cover that aspect of it, but then it should cover basically quite a bit of stuff in terms of that would make someone to say, okay, yeah, this patent attorney actually did his work and determined that it was not infringed, or the patent is invalid. And then I covered already the cost in terms of, there's court fees, attorney's fees that also can be included as a remedy when filing a complaint, and typically, I mean, everyone put that in there, but then I rarely ever see a court, give court fees or attorney's fee, but we put that in there anyway. Now, as far as injunction, okay, and so this is what I was mentioning about. This is what when I was at working for Ovonic, we're trying to get an injunction against the Toyota Prius, and so injunction there's there's really two type of injunction, and that actually, and then I think I'll talk about this later on too. Is that there's a preliminary injunction and a permanent injunction, and so a preliminary injunction is something that happens as soon as the court, you file a, which is basically a temporary restraining order, that you do it at the beginning of the trial, because a trial might last like 2-3 years, right? And so you want to get a preliminary injunction, hurry up in place, and so that way, you don't have to wait for a permanent injunction at the end of the trial. And so you get a preliminary injunction that you file early on, and then if you get a preliminary injunction, you go to hearing, or later on further down, closer to hearing time, then you ask for a permanent injunction, and then the permanent injunction is basically turning that into permanent injunction into a permanent injunction. That way it's that way it joins the party forever. Or or you can, if you didn't have a permanent injunction before, you can ask the court to issue a permanent injunction later in the case. Now here's some elements about permanent injunctions, that you need, right? So you have to have some likelihood that it's going to that you're going to succeed on the case. There's the irreparable harm to you. The harm is not weighted. The harm to the plaintiff outweighs the defendant's harm. So they have to kind of wait, saying that, okay, like there's going to be some harm to the plaintiff if they don't get the injunction, but then if they get the injunction, there's going to be harm to the defendant, right? So they're saying that, okay, like we're going to wait that and see if we should issue an injunction this time. Right? And also they look at, like, obviously, this is help, this is this the judgment of one way or the other. Does this serve any public interest? And permanent injunction, like a lot, the question is the same, right? So there's you still have to say that, like, yeah, there's there's a balancing here, and then that's the public interest aspects of it, and then the big question obviously here, which I brought up before when we're talking about with the injunction that Ovonic asked for injunction of the Toyota Prius, is that, hey, can monetary damage be adequate to remedy this, this harm? And so that's what the tribunal was trying to get at, saying, can we just, instead of injunction, I mean, the injunction's a big deal. Can we just say that, they owe you like $100 million and get it over with, And so the last part of it I'm going to go over is ITC disputes. And so ITC, is section 331 of the ITC. Is basically about, they call unfair importation, investigation, which is section 337 investigation. And so, the ITC is really a lot of times dealing with, they can deal obviously a lot of other issues besides IP, but then it does, but then you can bring an intellectual property right action before the ITC, and that would, basically, a lot of times what you're asking for is to prove, like saying that, hey, there's an infringement of these, and then we'll go over later on about saying, what kind of order that can be asked for. There's, the exclusion order, but there's two different types, which I'll talk about later on. So basically they're saying that, hey, instead of litigating this in a district court, you can litigate this in front of the ITC to stop the importation. And obviously the ITC can have power for something similar to an injunction that we talked about, but ITC cannot have any monetary damages, and so their scope is, or the damages, or what can resolve, is much narrower then you can get in a federal court. But then sometimes that's all the party or the plaintiff care about, right? All they care about is to prevent, importation of it. But then they don't care, they could care about damages. And again, it has to be importation here. And so if you think about saying that with the Toyota Prius, sometimes that might not work because they could be building the vehicle here in the US, right? I don't recall, I think at that time it was imported to the US from Japan, but then that's not something that, they could have just said, okay, well, build it in South Carolina instead of building in Japan and ship it over there. So in that case, no, we can't, the ITC would not be able to do anything. And so let's talk about how the ITC proceeding works. Okay, so ITC proceeding, it's in a way it's kind of similar to a district court proceeding. They can still seek for like discovery and all that stuff like that we talked about earlier. And also, there's a hearing. The big difference between there is, it's not before a jury. So ITC hearing is in front of the ITC administrative judges, and so you don't have a jury. So ideally, they're a little more sophisticated, hopefully, than a jury. And also the difference is that there's, they for the direct testimony rather than like in a trial, where I would do a direct of the witnesses. I would ask the witnesses, direct questions, right? So that, without leading, obviously, so asking questions, and they would come back and hear. Instead of doing that, they have a written witness testimony, and the other party obviously can still cross-examine the witnesses at the hearing, but then instead of like the traditional way of a hearing at a district court, I'm not directly questioning the witness, as somebody that's representing the plaintiff. Let's see. I'm going to make sure I got the right slide next. Okay, and so after the hearing, the ITC would have an initial determination, and so the initial determination would say, like, yes, is there infringement, and then what they think about the case so far, they hear so far. So the initial determination is something that basically, what both parties would have. And so after the parties review the initial determination, the parties can petition the ITC to re-review, the initial determination, based on some additional arguments. And then the ITC at that point can say, yes, okay, yeah, you're right. Your argument makes sense. We'll change our final determination. Or a lot of times the ITC just going to say, hey, we can stick with our initial determination, because both parties, the losing party obviously is going to file their petition. And so ITC, at that point can determine whether the initial determination was correct or not, in view of what the losing party argues. And so after the initial determination, they review the initial determination, and then they will issue a final determination, affirming or altering the initial determination. So that's final then at that point. And so there's two types of exclusion orders that ITC has, right? So there's a general exclusion order. So the general exclusion order, what that does is it blocks all infringing products, regardless of who the importer is or the manufacturer. And so this is what, the one that, if you're to file an ITC proceeding, this is the one that you really would like to have, because then it prevents basically some, let's say you have initial 5 parties or something like that. Then you get then you do not get a general exclusion order. Then somebody else can come along and then have an infringing product. Now you have to go through this whole process again. So that's what a limited exclusion order. And so it's only for the manufacturer, importer, identified investigation. So if there was 5 parties listed in here, the one that the exclusion order applies to, it's just for these 5 parties. And so that means that, like I mentioned before, that if there's a, new, additional parties after this is over, that go like, oh man, it's like, there's these other parties that's bringing this product in, then you have to do the whole ICC proceeding again for these other new parties. And so I mentioned before, actually, I guess maybe I didn't say, the complainant must meet a higher standard to obtain a general exclusive order. So, the general exclusive order covers all products, not just those of the named manufacturer importers, the respondents. And so there obviously needs to be a higher standard to get this general exclusion order. And so a general exclusion order, there has to be, proof of these two elements, right? So there's a widespread pattern of unauthorized use of the patent invention and certain business conditions from which one might infer that the foreign manufacturer, other than respondents' investigation, may attempt to enter the U.S. market, right? So basically, the one that's requesting the general exclusion order had to make arguments that these two elements apply here, and so that way it's not just these 5 here, but we expect there to be more. That's what this is really getting at, is that there's going to be more than just these 5, and so let's just get me a general exclusion order so I have to come back here a year from now when 2 more pop up. So let me go through a quick case study about general exclusion order and then how it came up, and one of the cases I worked on before. Okay. And so this case is Moen versus Foremost. And so Moen, I'm not sure if you guys are familiar with Moen, but Moen is a pretty popular bathroom faucet manufacturer in the United States. I would say they're probably one of the biggest manufacturer of bathroom faucets here, or not even bathroom faucets. I think I might even have Moen faucets for my kitchen too. So they're a big manufacturer of faucets. So Foremost International Trading, they're imported basically. They, they're import Chinese materials into component products into the U.S. And so the background of the case in the district court was that Moen introduces Monticello line of 2-handle faucet, and this is actually the #1 selling lavatory faucet for Moen at that time that we filed a complaint. And then Moen filed and also received the design patent, 466 patent for the design of the Monticello faucet. So here's figure 1 of the 466 patents, design patent. And I'm not sure if you're familiar with design patents, but then design patents are, there's utility patents, which I assume that you're familiar with, and those are the ones with the claims at the end. It's, like they go through a specific, drawing and specification and say, I claim, such and such. Design patent, there's not I don't know if it's called written specification or not, but I mean, it's basically all they do is refigure the figures, right? So figure 1 shows this, figure 2 shows this, figure 3 shows this. And so the design patent, the scope of the patent is not by the claim, but by the figures. And so here, figure 1, of the 446 design patent was of the faucet, and it shows 2 handles. And the reason why these are dotted, you can see, is that the dotted lines and the design patent is basically something that is not part of the claim. And so it says that there's 2 handles, but the handle can look like anything, which is true for the Moen faucets, because one of the things they do is that you can switch out the handles, or you can buy with different type of handles on there. And so really what we're looking at is this neck of the faucet, and then the shape of this faucet, of the base of the faucet. And so what happened was that Foremost start selling or importing into the United States faucets that looks very similar. I mean, they're just basically copies of the Moen faucet. And so Moen filed a complaint in the Northern District of Illinois. I mean, that's where I'm at, alleging that the faucet infringe the 466 patent, design patent. And so the way we were able to show infringement of the 466 patent is that we overlaid this figure 1 right here, which is perspective view of the faucet. We took a picture of the foremost faucet. We had a print of this figure 1 and a mylar. A mylar is like a plastic film that you can put images on. And then we put the mylar film right over the picture of the foremost faucet, and it was an exact fit, right? And so that's how we showed it, saying that, hey, these guys, have a design that looks identical to our design. Because I mean, we put our design right over the picture of their faucet, and it's a perfect fit. And so we were able to show infringement of that. And then we also, remember we talked about before permanent injunction. So we also went through the different steps, of the other element, and then show that, that we should get a permanent injunction until the judge issued a permanent injunction. Now, after the district court, the Northern District of Illinois, issued a permanent injunction against Foremost, Moen found out there were other companies that were importing the faucets that basically had similar design. And so, I mean, now it comes down to, do we file complaints against all these companies, or we just do an ICT proceeding against these other companies? And so we decided to file a complaint in the ITC, against Foremost and the 4 other companies that came up after we litigated or start litigating against Foremost, for importing products that infringe the 466 design patent. And so actually, to be honest with you, at that point, I kind of was supporting the ITC proceeding, because here in the United States, ITC proceedings are pretty unique, in terms of the process it's run. And so it's a little bit different, like I mentioned, the discovery is a little bit different, how the hearings held is different. And so a lot of times the attorneys that might litigate in federal court are not necessarily the type of attorneys that would litigate in ITC. So at this point, we are, at least for me, I wanted to kind of supporting the ITC proceeding in terms of providing them with arguments. And so basically, I work with an ITC attorney, and then that ITC attorney took the same arguments that we made in district court, for the permanent injunction, which some of the elements are very similar to, especially the infringement part of it, obviously. And also, like obviously they had to revise it somewhat to more accommodating to the ICC proceeding. And so the ITC proceeding eventually granted the general exclusion. And so the ICC proceeding, what they did was they have a final order, in its order, it says the commission has determined that a general exclusion of entry for consumption articles necessary to prevent circumvention of exclusive order limited to the products of named person, because there's a pattern of violation of section 337, and it's difficult to identify the source of the infringing product. Now, as you recall, those are the two elements that has to be shown for general exclusion. So, I'm left with half an hour, for any questions. So I'll turn it back to you then. Is there any other, has anyone asked any questions or anything that people asked that I can answer?
Yeah, Dan, thank you. Thank you so much for this wonderful talk. So now the floor is open for questions. Let's see if any of our audience has any question. I love your cases, Dan. Now,
oh, thank you. I thought that would make it more interesting than just than just talking about the law, because then if you apply the law to cases, I think that makes it much more easy to understand. And also kind of, it also gives a point of view saying, okay, this is what the attorney that's going through here thinks. rather than just, spewing out saying that a third person or something like that. This is, this is actually giving some insight into an attorney's view.
Yeah, right, exactly. I mean, if only talking about the law, the regulation is too dry.
Exactly, and people can't associate with it. To me, it's hard to associate with it. That's, I think that's true for, not just learning legal principles, but I know that, like when I was, let's say, an engineer or whatever, it's like, somebody just give you a formula. It's like, what does that do? But then when you try to apply it, then it makes a lot more sense.
Yeah, right. Maybe while our audience devising their questions, may asking you about one is starting from your last case, actually, the ITC case.
Mhm.
I mean, from my limited knowledge about ITC, I I don't see quite often about design patents, or am I wrong? And even in your case, I mean, in the case you mentioned, they get a GEO based on a design, design patent.
Yeah, so I mean that's an interesting point. I think design patents are underused in a way, in
Yeah.
this country. I mean, everyone's familiar with utility patents. Like when somebody asks about saying that, like, hey, is there, saying that I came up with an invention or I came up with something new, can we patent this? I think most people, and I apologize, I don't know if design patents are available in China or not. Um, but then here, obviously that's available, but a lot of people don't think about design patents, because design patents are supposed to cover the orientation of the product. And so not the utility aspects of it, but basically like what it looks like. So the actually, let me put it this way. It covers the non-functional aspects of the patent, of a product, right? So the functional aspects of it is supposed to be covered by utility patent. The
Yes.
non-functional aspects of it is covered by design patent. And a lot of people don't think about design patents that much when they're when they're filing for patent protection. In this case, we filed quite a few, and I mean this is actually back when litigation, a lot of times litigation and the prosecution attorney are the same people. And so one of my partners, filed the application. We actually we also filed quite a few utility applications, obviously, for Moen. But then in this case, because it's such a design. I mean, the design was such a famous design actually, because it was like I mentioned, it was one of the most popular faucet here, and that we felt like it's appropriate to file design patent. But then I don't know the breakdown of number of design patents versus utility patent applications, but I would think probably 10 times more, if not more, design, utility applications filed in the design patents. And so that's probably the reasons why you probably don't see much litigation taking place for design patents. And obviously, there's not that much litigation for design patents. There's not much litigation that takes place at ITC also, just because not that many people file design patents. But design patents actually, for something like this, I mean, the original case that dealt with the design patents, I'm sorry if I'm getting off topic here, but what was about a bottle, a unique looking bottle that was for wine, this wine bottle. And so somebody filed design patent for that to, um, to say that, like there's nothing functional about this, about this wine bottle. Maybe there is, I'm not sure, but that's not what that, that's not design patent cover. Maybe the shape of it somehow, reduces less oxygen being released. I'm not sure. But then that wasn't the main reason. The main reason, was that, that the way it looks is unique, right? So they want to, so, there's in the United States, there's also called trade dress, so trade dress, if you don't have a design patent, you can allege, a unique look about something as something a patent. Now, design patent, obviously now, you know, in addition to, you know, here, the faucet, you know, design patents is used quite a bit in terms of, I believe, now don't quote me this because I'm not positive, because I thought I read somewhere that, you know, some of the patents that like Apple went after Samsung, you know, you know, obviously there's, you know, functional aspects of it. They have some utility patents, but then there was a lot, obviously, a bunch of patents, but some of those are design patents. You know, they went after Samsung on saying that how the Apple phones, the iPhones, you know, the design of the iPhone was copied by Samsung in their you know, the
The
Galaxy
Galaxy.
phones.
Yeah.
Right.
Yeah.
So they look very similar. And so some of the things they did was that they went after them for, you know, not just utility patents, but they went for design patents. And then I recall like when I was looking at design patents for you know, like back before we had things online, right? This is 20 some years ago when we had, you know, some of the patent stuff that's printed out and we have to read it. So a lot of design patents even back then were like addressed to like tires, you know, tire, the treads on the tire. So some people would, you know, saying, okay, you know, like it's probably hard to patent a tread on a tire, right? And so they're being creative and saying that, you know, hey, this is, you know, this is something that we can protect with design patents.
Yeah, right. I mean, especially with the GUI, graphical user interface, I think design patterns, I mean, the stakeholders should, you know,
Right, exactly.
pay
That's true. Because
pay more attention. Yeah.
right, exactly. That's a good point because I think when I was at Accenture, we filed a couple of design patents, you know, on user interface kind of things like that. Those are a little, you know, we filed them, but I think it'd be easy to design around, and so I wasn't crazy about filing them. But then design patents are, you know, inexpensive, right? You know, so it doesn't cost a whole lot to file a design patent. You just had a couple of drawings, like you said, like
Yes.
user interface. I think that's what we did is, you know, like we had some on user interface, you know, and then even recently when I filed some applications or I had an application on a I believe it was a tape dispenser, you know, like a tape dispenser for you know, like packaging, you know, like those tape dispensers that you put on, you know, to close off the boxes, right? So they had some unique features about the handle in terms
Yeah.
of
Mhm.
you know, that how it holds the tape in place and stuff like that. You
Mhm.
know, so I filed a utility application for that. But at the same time, I also filed the design patent for it because, you know, like there was certain um chevron, you know, chevron is kind of a pattern, right? Pattern that was on the handle. But I thought, well, you know what, we might as well, it doesn't, you know, doesn't cost that much more. So we just went ahead and filed some design patents on the handle, the chevron on the handle.
Yeah. And by the way, when you are talking about I think it is at your the court case, the district court case, the strategy you made. I mean, you printed out the photo of what was the name, the foremost
Yeah,
product,
foremost,
and
right? So we,
yeah,
yes.
and we that's a very nice strategy. I think I read on some news uh, during the Apple versus Samsung case. I believe the attorney for Apple did something similar to this strategy.
Hey, they copy me. No, but I mean that's probably the best. That's probably the best way to show infringement. And
Yeah.
I kind of recall that took a long time to get because I mean basically we had you know, because it's a perspective view, right? So it wasn't easy to figure out how to get that shot. And I remember like I think I spent like a whole day with a photographer. We keep adjusting the camera, you know, the
Yeah.
angle and stuff like that until it lined up
Yeah.
perfectly with
Mhm.
figure one. You know, because I mean, how else? I mean, like I guess ideally you can have figure one on one side, you can have the product on the other side, and say, hey, look how close it is. And that's just, you know, that's not nearly as convincing as, you know, having it figure one on a Mylar sheet and just you know, put it right in front of it and then you look at it, it's like, yeah, it fits,
Yeah.
it fits right in there, looks just like it.
Yeah, right, right, right. Uh, okay, so and still, also this case, I think, I'm not sure whether the ITC case, I mean, the strategy is purposely done this way or not. I mean, you guys got a permanent or preliminary injunction at the district court, a permanent
Oh, we got a
injunction,
permanent
right?
injunction. We got a permanent injunction.
Yeah. Actually, for a permanent injunction in court case, it should also cover, stop importation into US, right? I mean,
Yes,
theoretically.
but only against Foremost. And so in a way, Foremost
Yes,
was almost kind of a duplicate. So we actually stopped them two ways, two times, right? So we stopped them already in a permanent injunction. I mean, that's a good point because I mean that's kind of like why did we include Foremost in the ITC proceeding if we already had a permanent injunction
right.
against Foremost? And I mean that's a very good question.
So you have a
The
strong
reason
argument before ITC, I think.
Well, exactly. That's why we did it.
Yeah,
We already have a permanent injunction, and so that way, if we bring Foremost into the ICT proceeding, I mean, it's more strategic point, right? The reason we did it, not necessarily that we needed ITC to give us, a general exclusion order against Foremost. Or that would exclude Foremost because we already got that at the district court level. But then because we brought in Foremost, and so we were able to, or actually not me, because I was the litigation attorney for the district court, but then the ITC attorney, they were able to bring in all the stuff that that we argued successfully in front of the district court. And so they're saying that, hey, these guys got a permanent injunction. And then the judge held that it was, infringed. The judge held that, for public reasons that this is, it's weighted toward that it should be injunction. So they can bring in all this stuff, right? That we made, all the arguments we made in district court, and then be able to say the judge decided this. A district court judge decided this already. So you guys should decide the same thing. And so by bringing Foremost in, it's easier for us to kind of refer back to their product and then the reason why the judge decided that originally for the district court case and bring it, and then bring that in front of the ITC. So yeah, so you're absolutely right, is that we really didn't need to bring Foremost in, but that was more of a strategic reason to bring it in. So that way we introduce, all the things that happen at district court.
yeah, right. The strategy is very important. So, by the way,
Right.
yeah, go ahead.
Oh no, I was gonna say, yeah, that's the one thing is throughout my, I don't know, 25 years of litigation, is that like strategy, I hate to say it, but strategy sometimes is just as important as the facts of the case. How it's presented and how you do it is sometimes very important.
Yes, can
Uh,
agree more. Yes. Also, I think back to the earlier part of your presentation, you mentioned for a patent owner, normally you don't say directly to the potential infringer, hey, you are infringing, you are possibly
right,
infringing.
exactly.
You say
Exactly.
you should consider taking license. So what's the
Yeah, so
thought
that
behind?
was what we are talking about before with the declaratory judgment. I'm not sure, maybe I didn't make that clear. And so maybe I can go back. I'm not sure if I can find that section. Maybe I can't. Where I talked about that. But then there was declaratory judgment, as far as there's two ways to bring a case into court. Right. And so
Yep.
here it is. Okay.
Yep.
So ways to initiate a patent dispute. Okay. So there's in the federal district court, there's two ways to bring a case before the federal district court. So the first one is, the patent owner to file a patent infringement claim, saying that, hey, there's this company out there, they infringed my patent, and then I either ask for damages or an injunction, And so the other way to do it is to file the declaratory judgment against the panel. And so the declaratory judgment is by the alleged infringer. And so the alleged infringer will file something in the court saying that I do not infringe this patent, or I do not, or the patent is invalid. Okay? And so there has to be, in order for somebody to file a claim, like I mentioned, there has to be an issue there has to be a controversy already.
Mm-hmm.
So it can't be just saying that, I want to file this for no reason at all, because I don't like this guy, so I'm going to file this, saying that his patent is invalid. It's sad, but you can kind of do it with the patent office, but you can't do it with the federal court. There has to be some kind of controversy in place.
Gotcha.
And so the controversy, you have to point to something that's saying there's a controversy. And so the way to do that is that, like there has to be, somebody has to allege that you infringed. So there has to be a letter that says you infringe, or or sometimes there's I might have at a conference, and then these guys come up and say, we think you infringe, and then if you don't stop it, we're going to sue you.
Mm-hmm.
And so you can point to like a letter, you can point to a conversation, saying that these guys say that I infringe their patent. And so there's the controversy there. And so now when I file my declaratory judgment, I said, yeah, there's a controversy here because these guys allege that I infringe. And so the way people have been getting around that is that they never say you infringe. They say, they say, you know what, I have a patent here, and I think you should get a license for my patent. If you read between the lines, that's basically saying you infringe. If you, why else would you want a patent, right? A license to my patent, unless you infringe. And so here, they're trying to get around the declaratory judgment. They don't want, because declaratory judgment, like that goes to what we're talking about, next, like in this presentation, is like the forum, right? A lot of times people file declaratory judgment because they don't want to be stuck in like Texas,
Yeah.
We don't want to be in Texas. So I'm going to file declaratory judgment in Northern District of California, and so if you're or whatever, let's say, or whatever, let's say I don't want to be stuck in like, even let's say the case that Ovonic case. I don't want to be, I'm Toyota. I don't want to be stuck in Eastern District of Michigan, where Detroit is. Your whole, I'm going to get killed over there. Nobody likes me. Nobody likes Toyota in Detroit. So there's reasons to do that, and also like I said, like another reason why declaratory judgment come to play was like what that one client I had, in which he was a Chinese company that makes light switches. All his clients, his customers, who sells the product in here was being sued. But then now he's getting stuck with the bill because he provided indemnity. So he wanted to file declaratory judgment so that way he can go after these guys. And then maybe the company that sued him, I'm sure the company that sued him know who he is, right? And so he doesn't, so they never approached him and said that he infringed, And so we were trying to think about saying, okay, what is it that we can say on a declaratory judgment? It would be, because they never came back and said that, hey, your product infringed. They never even contacted him. They only sued his client. But then so we have to find some maybe creative way saying that, yeah, there's there's a controversy because my client is sued, and so there's a controversy there. So that's how we would approach it. But then like I said, it's a lot of times the declaratory judgment is filed for a forum. And so there's not like another party here that you can kind of rely for declaratory judgment. But then here, they're just saying that, you might want a license for my patent. So that way, they say, hey, like I want to I'm going to file this case in whatever Northern District of California. He said, what, so if you're the panel, he said, what are you talking about? There's no controversy here. We never alleged you infringed.
Yep.
All we said you might want a license.
Yep.
It's playing with words, unfortunately.
Yeah, strategy again. Yes.
Right,
yes.
right.
Okay. Okay. Thank you. So probably we are not seeing more questions come in. Maybe because it's getting late.
Yeah, I know it's
and
pretty late for you, and I apologize
especially because
taking up my whole 3 hours.
Yeah.
Usually I have to
thank you.
rush through this, but I was glad that you gave me some extra time.
No, I mean, even that, I think you are not having, enough time. I know, from your side, there are too much you can speak about.
Right. Yeah. I mean, there's
Yeah.
it's such a broad area. I mean, I can probably
Yes.
talk
Yes.
about this
Yeah,
like all day
absolutely.
long.
Absolutely. Yes. Okay. But anyway, thank you so much. So, if we have no more questions, so if I may, let's conclude. So, really, really thank you. Dan, for giving a so wonderful lecture. Full of knowledge and also in a very systematic way. From the basic concepts to forum shopping to specific strategies in different tribunals. And and I believe the audience really, really enjoy your real world examples. We can.
Oh, thank you.
We can almost see vivid pictures in front of
Right,
us. Yeah, that's very nice. Very nice way to doing a webinar. So especially we cannot see each other. It's not like offline events. You can see people can see you. Yeah. So thank you. We hope someday we can have you on site. So people can.
Oh, I would love to do that.
Yeah. We can meet a person in person. Okay. So if we have no more questions, so maybe we can conclude here. And again, thank you so much, Dan, for your precious time and giving this wonderful lecture to us. And let's keep the talks. And
Okay.
you have a good day ahead.
Yeah, thank you so much.
Okay, so
Okay.
maybe we can stop here now. So see you next time.
Okay,
So
thank
bye
you.
bye, everybody.
Bye.
Bye bye, Dan. Bye. Take care.
Bye.
Bye.